Welcome to this lecture. In this lecture, I will discuss the offenses against the body, more specifically of offenses affecting the human life. And in this particular lecture, we will discuss the transfer of malice that is provided under section 102 of the Bharatiya Nyaya Samhita, that is culpable homicide by causing death of person other than person whose death was intended. Section 102 of the Bharatiya Nyaya Samhita provides that if a person, by doing anything which he intends or knows to be likely to cause death, commits culpable homicide by causing the death of any person, whose death he neither intends nor knows himself to be likely to cause, the culpable homicide committed by the offender is of the description of which it would have been if he had caused the death of the person whose death he intends or knew himself to be likely to cause. Section 102 of the Bharatiya Nyaya Samhita corresponds to Section 301 of this Indian Penal Code. The underlying idea behind Section 102 appears to be that where an act is in itself criminal, the doing of the act is an offense irrespective of the individuality of the person harmed. It is a common knowledge that a man who has an unlawful and malicious intent against another, and in attempting to carry it out, injuries or injures a third person, is guilty of what the law deems malice against the person injured, because the offender is doing an unlawful act and has that which the judges call general malice, and that is enough. The English doctrine of transfer of malice or the transmigration of motive has been embodied in section 102 of the Bharatiya Nyaya Samhita. Here, if A intends to kill B but kills C, whose death he neither intended nor knows to be likely to cause, the intention to kill C is by law attributed to him. For example, if A aims his shot at B, but he misses B either because B moves out of the range of the shot or because the shot misses the mark and hits some other person, say for example C. Whether within sight or out of sight, under section 102, A is deemed to have hit C with the intention to kill him. Section 102 of the Bharatiya Nyaya Samhita makes it clear that culpable homicide may be committed by causing the death of a person whom the offender neither intended nor knew himself to be likely to kill. But whether the offense is murder or culpable homicide will depend upon the intention or knowledge which the offender had in regard to the person intended or known to be likely to be killed or injured, and not with reference to his intention or knowledge or with reference to the person actually killed. Transferred intention occurs when an injury intended for one falls on another. The doctrine is subject to the following qualification. The first one is the harm that follows is to be of the same kind. The reason is that otherwise too great violence would be done to the doctrine of mens rea and to wording of the statute under which the charge is made. One cannot be condemned if his mens rea relates to one crime and actus reus to different crime, because that would be to disregard the requirement of an appropriate mens rea. Second, since the law of transferred malice does not dispense with the need of proof of the usual mens rea, it follows that defenses are in effect transferred from the malice. Thus, there is no guilt if the intended force was lawful, unless the accused was criminally reckless or negligent in respect of the actual victim. Glanville Williams suggested that transferred malice should be limited to cases where the consequence was brought about by negligence to the actual victim. Varying opinions have been expressed about the desirability of such a doctrine. Some say that the doctrine is an arbitrary exception to normal principles. Others say that probably the reason for the doctrine is emotional one. In a moral view, it may be thought that a person who attempts a crime is as bad as he who by better fortune manages to consummate it. Punishment as a moral expiation should fall upon both with the same severity. In view of some, the only theory that explains the present law is crude relation theory, where the degree of punishment is linked rather to the amount of danger done than to the intention of the actor. Liability for homicide by mistake. A person killing by mistake a man other than he intended to kill is, as regard his criminality, in the same position as if he had killed the person he intended to kill, where A gave a poisoned apple to his wife, intending to poison her, and the wife, ignorant of the matter, gave it to a child who took it and died. He would be guilty of murder, even though he, being present at the time, endeavored to dissuade his wife from giving the apple to child. If a person prepares poison with intent to kill any reasonable creature, such person is guilty of murder of whatever reasonable creature is killed thereby. In a case, the accused, who was carrying on an adulterous intrigue with the wife of one B, intending to kill him, waylaid him in a dusk and struck a man as he was coming along the road. Mistaking him for B, he was guilty of murder. In another case, A aimed a blow with a highly lethal weapon like a sharp dagger, intending to hit B, but it fell on and killed her child. He was guilty of murdering the child. In other case, B, with the intention of killing C, on whose life he had effected insurance, gave him some poisoned sweetmeat. She ate some of it and threw the rest away, which was picked up by the daughter of B's brother in law, aged about 8 years, without the knowledge of B. She ate it and gave some to another child also. The two children died from the effect of the poison, but C recovered. B was held guilty of murder. A fired his gun at B with the intention of causing his death. The bullet missed the target and hit C, who was standing there. Here A is liable for causing murder of C as a doctrine of transferred malice as contained in section 102 Bharatiya Nyaya Samhita will apply. A intended to kill B, but he missed the target and C was killed. His liability in this case would be that as it would have been if B was killed by A. Another example, A finding B attacked by C with knife, shoots at C, thereby intending to save B. The shot misses C and kills B. In this case, A intended to fire at C in order to save B, who was attacked by C with a knife, which was likely to cause either grievous hurt or death. Had A caused the death of C, he would not have been entitled to claim the defense under section 38 Bharatiya Nyaya Samhita, and his act would not have amounted to an offense. Therefore, A acted in good faith to save B from the deadly attack by C, but unfortunately B was killed. as the shot missed C and hit B. Therefore, A is not liable for any offence in this case. The principle of transfer may lies as contained under section 102 Bharatiya Nyaya Samhita shall apply. Section 104 of the Bharatiya Nyaya Samhita 2023 that provides punishment for murder by life convict. It provides whoever, being under sentence of imprisonment for life, commits murder, shall be punished with death or with imprisonment for life, which shall mean the remainder of that person's natural life. Section 104 Bharatiya Nyaya Samhita 2023 corresponds to Section 303 of the Indian Penal Code. The legislative change which has taken place from this original Section 303 of the Indian Penal Code to Section 104 Bharatiya Nyaya Samhita it was mandatory to award death sentence for murder by a life convict. That is, under Section 303 of the Indian Penal Code, it was mandatory to award death sentence for murder by a life convict. Now, Section 104 of the Bharatiya Nyaya Samhita provides a discretion to the judge to sentence the life convict murderer to either death sentence or imprisonment for life, which shall mean the remainder of that person's natural life. The punishment prescribed under this section, that is section 104, will apply even in those cases where a person undergoing imprisonment for life is convicted either under section 302 read with section 34 of the Indian Penal Code, that is section 103 subsection 1 read with section 3 subsection 5 of the Bharatiya Nyaya Samhita, or under section 302 read with section 149, that is with having the common object of Indian Penal Code, that is section 103 subsection 1 read with section 190 of the Bharatiya Nyaya Samhita 2023. But a convict whose sentence of life imprisonment has been remitted without condition by government cannot be said to be under a sentence of imprisonment for life, and therefore this section will not apply in that very case. The constitutionality of section 303 of this Indian Penal Code was challenged in a very important case, Mithu versus the state of Punjab, and it was held by the court that in Mithu versus the state of Punjab, in which the legality of section 303 of the Indian Penal Code was examined by the full bench of the Supreme Court, the majority opinion was that this section violates the guarantee of equality contained in Article 14 and also the right contained in Article 21 of the Constitution. The section was held to have been conceived to discourage assault by the life convicts on the prison's staff, but the legislature chose a language which far exceeded its intention. It was further held that the section proceeds on the assumption that life convicts are a dangerous breed of humanity as a class, but that assumption is not supported by any scientific data. The majority view was that it mainly violates Article 21 of the Constitution. In Bhagwan Bakhsh Singh versus State of Uttar Pradesh, this section has been declared unconstitutional because it is violative of Article 14 and 21 of the Constitution of India. Now it is no longer available for conviction of any offender. A conviction under this section will be altered to one under section 302 of the Indian Penal Code, that is section 103 subsection 1 of the Bharatiya Nyaya Samhita. But for awarding death sentence under section 302 Indian Penal Code, it must be established that the case is rarest of rare cases. If the case cannot be termed as rarest of rare cases, the sentence would be converted into sentence for life. Death sentence not mandatory under section 104 BNS. We have seen that under section 303 of this Indian Penal Code, it was mandatory to award death sentence for murder by a life convict. The provision was held to be unconstitutional by Supreme Court in Mithu Singh versus State of Punjab. Now, Section 104 of the Bharatiya Nyaya Samhita provides a discretion to the judge to sentence the life convict murderer to death sentence or imprisonment for life. Section 105 of Bharatiya Nyaya Samhita now, that provides punishment for culpable homicide not amounting to murder. Section 105 Bharatiya Nyaya Samhita provides that whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years, and shall also be liable to fine if the act by which death is caused is done with the intention of causing death, or of causing such bodily injury as is likely to cause death, or with imprisonment of either description for a term which may extend to 10 years, and with fine if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death, or to cause such bodily injury as is likely to cause death. Section 105 of Bharatiya Nyaya Samhita corresponds to Section 304 of the Indian Penal Code that provide punishment for culpable homicide not amounting to murder. Section 105 Part 1 of Bharatiya Nyaya Samhita correspond to Section 304 Part 1 of Indian Penal Code that provides intention to cause death or bodily injury likely to cause death. Section 105 Part 2 of Bharatiya Nyaya Samhita corresponds to Section 304 Part 2 of the Indian Penal Code, that is knowledge on the part of the accused person that the act is likely to cause death. The legislative changes that has to be remembered, that is Section 304 Part 1 of the Indian Penal Code provided punishment for life imprisonment or imprisonment which may extend to 10 years and fine. Whereas Section 105 Part 1 of the Bharatiya Nyaya Samhita provides punishment for life imprisonment or imprisonment which shall not be less than 5 years, which may extend to 10 years and fine. Section 304 Part 2 of the Indian Penal Code provided punishment for imprisonment which may extend to 10 years or fine or with both, whereas Section 105 Part 2 of Bharatiya Nyaya Samhita provides punishment of imprisonment which may extend to 10 years and fine. This section provides punishment for two separate degrees of culpable homicide, depending upon the intention to cause death or bodily injury likely to cause death. Under Part 1 and knowledge that the act is likely to cause death under Part 2. In a case, the accused during a quarrel lifted and threw on the ground from some distance with sufficient force to one D, who was an old man with an enlarged and floppy heart. These rifts were fractured and he died of rupture of the heart. It was held that the accused was liable under Section 325 IPC, that is Section 117, subsection 2 of the Bharatiya Nyaya Samhita, for causing only grievous hurt and not under Part 2 of Section 304 Indian Penal Code, that is Part 2 of Section 105 of the Bharatiya Nyaya Samhita, because he had no intention or knowledge to cause death. The Supreme Court in Lagan Bhai Darji Bhai Waswa versus State of Gujarat summarize the parameters which are to be taken into consideration while deciding the question as to whether a case falls under Section 302 IPC, that is Section 103, subsection 1 of the Bharatiya Nyaya Samhita, or Section 304 of the Indian Penal Code, that is Section 105 of the Bharatiya Nyaya Samhita. They are as follows. Number 1, circumstances in which the incident, that is offense, took place. Then B, nature of the weapon used. C, whether weapon was carried or was taken from the spot. D, whether the assault was aimed at vital part of the body. Then E, the amount of force used. Next, whether the deceased participated in the sudden fight. Next, whether there was any previous enmity. Next, whether there was any sudden provocation. Next, whether the attack was in heat of passion, and whether the person inflicting the injury took any undue advantage or acted in a cruel or unusual manner. In the instant case, there was a sudden altercation between accused, that is husband, with his wife on delay in preparation of food, which led husband to pick up a wooden object and hit the deceased, that is wife, on her head. Her death took place 10 days after this incident while she was under treatment in hospital. Thus the incident took place in spur of moment and only one single blow was struck. There was nothing to show that relationship between accused and his wife were not cordial. Therefore, the Supreme Court held it to be a right case to alter the conviction of the accused from Section 302 to that of Section 304 of the Indian Penal Code. In another case, in the state of UP versus Lakshmi, the respondent was charged with the offense of murder. The trial court held him guilty under Section 302 Indian Penal Code, that is Section 103, subsection 1 of the Bharatiya Nyaya Samhita. But the High Court acquitted the respondent owing to non-reliability of witnesses. The accused admitted the fact that he murdered his wife, but High Court did not attach any importance to it. The Supreme Court on examination found that because the accused had seen one of the prosecution witnesses near his wife, which enraged him and he murdered his wife, the Supreme Court allowed the benefit of grave and sudden provocation to the accused and held him liable under Section 304 of the Indian Penal Code, Section 105 of the Bharatiya Nyaya Samhita, and not under Section 302 of the Indian Penal Code, that is Section 103, subsection 1 of the Bharatiya Nyaya Samhita, to say that in this case, the exception of provocation was extended to the accused person, and under the circumstance, what would otherwise be an offense of murder, because there was a deliberate killing, it has been reduced to the offense of culpable homicide not amounting to murder, and therefore the accused was liable under Section 304 of the Indian Penal Code and not under Section 302 of the Indian Penal Code. In another case, in the case of Devendra Nath Srivastava versus the state of Uttar Pradesh, there was a quarrel between accused and his wife on 12th May 205. On 12th May 2005, during which the accused, that is husband, assaulted his wife with brick in a fit of anger in his house, resulting in her death. The trial court held the accused guilty of offense punishable under Section 302 Indian Penal Code, that is now Section 103, subsection 1 of the Bharatiya Nyaya Samhita. The High Court converted appellant's conviction from Section 302 Indian Penal Code to Section 304 Part 1 of the Indian Penal Code, that is Section 105 Part 1 of the Bharatiya Nyaya Samhita, and awarded 10 years rigorous imprisonment with fine and with default stipulation. The Supreme Court upheld the order of the High Court and sentencing the appellant to 10 years rigorous imprisonment with fine instead of death sentence awarded by the trial court, where the accused, that is husband, strangulated his wife to death due to asphyxia in a sudden quarrel, which was without any premeditation, and the accused had not taken any undue advantage or acted in a cruel or unusual manner. The conviction of the accused was rightly altered from Section 302 IPC, that is Section 103, subsection 1 of the Bharatiya Nyaya Samhita, to Section 304, Part 1 of Indian Penal Code, that is now Section 105, Part 1 of the Bharatiya Nyaya Samhita. The Supreme Court upheld the judgment of the High Court and alteration of punishment also. Main distinction between Exception 1 and Exception 4 to Section 300 Indian Penal Code. Exception 1 and Exception 4 to Section 101 of the Bharatiya Nyaya Samhita is that while in Exception 1 there is a total loss of self-control, whereas in Exception 4 of Section 101 of the Bharatiya Nyaya Samhita there is heat of passion which cloud one's sobriety. Tholan versus State of Tamil Nadu. In this case, the accused started remonstration using filthy language against certain organizers of a chit fund who had no connection with the deceased in front of the house of the deceased. The deceased came out of his house and asked the accused to go away. The accused, on spur of moment, gave only one blow with knife to the deceased and pushed him to some distance. The accused could not be attributed on these facts of requisite intention to commit murder, though he could be attributed with knowledge that he was likely to cause injury which was likely to cause death. He was held guilty under this part of the section. In Jagat Singh versus State, a dispute arose between the appellants and the family of the deceased while watching television. Next day, when the deceased with his family was going to lodge a report to the police, the accused attacked them at the bus stand of the village. The deceased was given a good beating, and when he fell down on the ground, the appellant sat on his chest and he, with one subram, twisted the neck of the deceased. He was taken to the hospital where the doctor declared him dead. The accused were held guilty under this provision because in the circumstances it could be safely said that they had the knowledge that their act was likely to cause death, although they had no intention to kill him. Section 106 of the Bharatiya Nyaya Samhita. Section 106 of the Bharatiya Nyaya Samhita that provides causing death by negligence. That is the punishment when a death is caused due to negligence. Subsection 1 of Section 106 provides, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years, and shall also be liable to fine. And if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Explanation to this section provides, for the purposes of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019, that is the 30 of Act of 30 of 2019, and whose name has been entered in the National Medical Register or a state medical register under the Act. Subsection 2 provides, whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Section 106 of the Bharatiya Nyaya Samhita corresponds to Section 304A of Indian Penal Code. It has to be noted about the legislative changes that has taken place in Section 106 of the Bharatiya Nyaya Samhita to that of Section 304 of the Indian Penal Code is that Section 304A of IPC, that is Indian Penal Code, that provides causing death by negligence, provided punishment of imprisonment up to 2 years or fine or both. Whereas Section 106 subsection 1 of the Bharatiya Nyaya Samhita provides for punishment of imprisonment which may extend to 5 years and fine. Section 106 subsection 1 of the Bharatiya Nyaya Samhita further provides that if rash or negligent act not amounting to culpable homicide is done by a registered medical practitioner while performing medical procedure causing death of any person, he shall be punished with imprisonment for a term which may extend to 2 years and fine. Section 106 subsection 2 of Bharatiya Nyaya Samhita is a new provision. It deals with hit and run cases. Situations where the offender causes death of any person by rash and negligent driving not amounting to culpable homicide and escapes from the scene of incident without reporting it to a police officer or magistrate after the incident. The punishment provided is imprisonment which may extend to 10 years and fine. For the application of this section, it is necessary that death is caused by doing a rash or negligent act, and such act must not amount to culpable homicide. Thus, this section shall apply where there is neither any intention to cause death nor knowledge that the act would in all probability cause death. To impose criminal liability under this section, it is necessary that the death should have been the direct result of a rash or negligent act of the accused, and that act must be the proximate and efficient cause without the intervention of another's negligence. It must be the causa causans. It is not enough that it may have been the causa sine qua non. That is culpable. Rashness is acting with consciousness that the mischievous and the illegal consequence may follow, but with the hope that they will not, and often with the belief that the actor has taken sufficient precautions to prevent their happening. Culpable negligence is acting without the consciousness that the illegal and mischievous effect will follow, but in circumstances which show that the actor has not exercised the caution required of him, and that if he had, he would have had the consciousness. The imputability arises from the neglect of the civic duty of circumstances, where a chemist gives date expired medicine to a patient and the patient dies, the chemist would be liable for causing death by negligence because he has failed to exercise due caution to ascertain whether the medicine that he was giving was expired date or not. Rash or negligent act. For example, a rash act is primarily an over hasty act and is thus opposed to a deliberate act, but it also includes an act which, though it may be said to be deliberate, is yet done without due deliberation and caution. Negligence is the breach of duty caused by omissions to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or the doing of something which a prudent and reasonable man would not do. Rashness and negligence are not the same thing. Mere negligence cannot be construed to mean rashness. Negligence is the genus of which rashness is a species. The word rashly and negligently are distinguishable, and one is exclusive of the other. The rash or negligent act means the act which is the immediate cause of death, and not any act or omission which can almost be said to be a remote cause of death. In order that rashness or negligence may be criminal, it must be of such a degree as to amount to taking hazard, knowing that the hazard was of such a degree that injury was most likely to be caused thereby. The criminality lies in running the risk or doing such an act with recklessness and indifference to the consequences. In cases relating to rash driving, it is the duty of the driver to drive his vehicle at a speed which will not imperil the safety of others using his road. In order to hold a driver criminally liable, it must be proved that the collision was entirely or at least mainly due to rashness or negligence on the part of the driver. It would not be sufficient if it was only found that was driving the vehicle at a very high speed. A person driving a car is under a duty to control the car. He is prima facie guilty of negligence if the vehicle leaves the road and dashes into a tree, and it is for the driver to explain the circumstances under which the car had left the road. Those circumstances may be beyond his control and may exculpate him, but in the absence of such circumstances, the fact that the car left the road is evidence of negligence on the part of the driver. Where due to collision of a vehicle, injury or death is caused, it cannot be taken for granted that the driver of the vehicle involved in the accident was guilty of the crime. There may be exceptional cases where the rule res ipsa loquitur applies. Ordinarily, it is for the prosecution to establish the guilt of the accused beyond reasonable doubt. Speed alone is not the criterion for deciding rashness or negligence on the part of the driver. A motor vehicle is intended to be driven in a speed. The relationship between speed and rashness or negligence depends upon the place and time. In a straight wide road where obstruction from other vehicles or pedestrian are not there, it cannot be said that driving in speed or absence of sounding horn by itself will amount to rashness or negligence. Then negligent act not amounting to culpable homicide. It was observed by Allahabad High Court in Idu Beg case that section 304A Indian Penal Code, that is section 106 of the Bharatiya Nyaya Samhita, is directed at offences outside the range of section 299 and section 300 of the Indian Penal Code, that is section 100 and 101 of the Bharatiya Nyaya Samhita 2023, and obviously contemplates those cases into which neither intention nor knowledge enters. For the rash or negligent act which is declared to be a crime is one not amounting to culpable homicide, and it must therefore be taken that intentionally or knowingly inflicted violence, directly and willfully caused, is excluded. Section 304A IPC does not say that every unjustifiable or inexcusable act of killing not hereinbefore mentioned shall be punishable under the provision of this section, but it specifically and in terms limit itself to those rash or negligent acts which cause death but fall short of culpable homicide of either description, that is, of culpable homicide or murder, where A takes up a gun not knowing it is loaded, points in sport at B, and pulls the trigger. B is shot dead. A would be liable for causing the death negligently under this section. Then contributory negligence. Contributive negligence is no defense to a criminal charge. However, under the law of tort, contributory negligence is to some extent is a defense to liability, that is liability. A criminal charge shall be sustainable if the accused had been at fault, even though someone else may have been equally at fault. In such cases, the question is, did the accused rashly or negligently do an act which was likely to endanger the public? If he did such an act, the fact that the actual injury was brought about by carelessness or contribution of the victim also will be no defense. In a case where a homeopathic practitioner administered to a patient suffering from guinea worm 24 drafts of stramonium and leaf of dhatura without studying its effect, and the patient died of poisoning, it was held that the doctor was guilty of causing death by doing an act negligently. Similarly, in D'Souza, a, a compounder, while preparing a fever mixture, took out certain medicine from a bottle without reading its label and mixed it in the mixture. The mixture was administered to 8 persons, out of whom 7 died. The bottle was marked poison and contained strychnine hydrochloride and not quinine hydrochloride, as he supposed it to be. The compounder was held guilty under this section. A kept the bottle of medicine in a shelf where some other bottle containing poisonous solution for photography business were also kept. In a state of drunkenness, before going to bed, A mistakenly gave his ailing wife the poisonous solution, as a result of which she died. Here A is liable for causing death by negligence under section 304A of Indian Penal Code, that is section 106 of the Bharatiya Nyaya Samhita. Since A was voluntarily drunk, he cannot claim the protection of section 86 Indian Penal Code, that is section 24 of the Bharatiya Nyaya Samhita. Then another issue with reference to section 106 subsection 2 that provides of the hit and run cases of the Bharatiya Nyaya Samhita. The hit and run cases which is provided under section 106 subsection 2 of the Bharatiya Nyaya Samhita is a new provision that addresses situation where an offender flees the scene of an incident without reporting it to the authorities. The provision aims to tackle the rising trend of hit and run cases, particularly those resulting in fatalities due to reckless driving. Indian Penal Code did not have a specific provision for hit and run cases, and action in such cases were taken under section 304A of Indian Penal Code, which attracted a maximum jail term of 2 years or fine. Now, section 106 subsection 2 of the Bharatiya Nyaya Samhita 2023 provides or states the situation where the offender causes death of any person by rash and negligent driving not amounting to culpable homicide and escapes from the scene of incident without reporting it to a police officer or a magistrate after the incident. The punishment provided is imprisonment, which may extend to 10 years, and also fine. The introduction of this provision is a proactive step to address the inadequacies in the existing legal framework concerning hit and run accidents, emphasizing the importance of immediate reporting to save lives. Distinction between Section 106 and Section 105 Part 2 of the Bharatiya Nyaya Samhita. That is an important distinction, and it is imperative or compulsory to make the distinction at this point to understand the law on the issue. It must be stated that distinction between causing death by rash and negligent act, as understood in Section 106, and culpable homicide not amounting to murder under Section 105 Part 2 of the Bharatiya Nyaya Samhita is very thin. The former is an act of omission, while in the latter there is a knowledge of the consequences attributed though unintended. It is the knowledge aspect that needs to be defined and considered carefully in application of Section 105 Part 2 of the Bharatiya Nyaya Samhita. A person would have knowledge that driving rashly and negligently would result in death of some passerby or even other motorist. The knowledge of sleeping laborers on Mumbai pavement is something which all vehicle drivers would have, and therefore to impose legal obligation on a person to drive his or her vehicle carefully, particularly during night time. In film actor Salman Khan's case, that is 2015, since the FIR stated that the actor was drunk and driving at 10 km per hour from Juhu to his house, Bandra in Mumbai, the trial court held him guilty of offence under Section 304 Part 2 of Indian Penal Code, that is Section 105 Part 2 of the Bharatiya Nyaya Samhita, holding that, like the Pericia's case, he had knowledge that bakery workers slept on the pavement outside the bakery on Hill Road near his house, coupled with the knowledge that the driving drunk in fast speed late in the night could result in car crash. He was convicted under Section 304 Part 2 of Indian Penal Code and sentenced to 5-year imprisonment for killing one person who was crushed to death by his court's order before the Bombay High Court, praying that his case fell under Section 279 Indian Penal Code, that is Section 281 of the Bharatiya Nyaya Samhita, and not under Section 304 Part 2 IPC. He was, however, released on bail pending the appeal. Thank you.